My name is Barbara McDonald. I was the Commissioner leading the inquiry into serious invasions of privacy in the digital era. Our inquiry took place over 1 year from 2013 to 2014, with our report tabled in Federal Parliament in September 2014. We had quite a wide brief. We had to provide recommendations on the detailed legal design of a statutory cause of action for serious invasions of privacy, with a number of the fine details which previous Law Commission reports elsewhere perhaps had not needed to go into, such as limitation periods and a number of other very specific points. But our brief wasn't just to look at a statutory cause of action. We were also asked to make recommendations about other innovative ways in which the law could reduce or redress serious invasions of privacy in the digital era, and to ensure that we were balancing the value of privacy with other fundamental values such as freedom of expression. The final report has about 2/3 on the statutory cause of action, and that was a very interesting process to actually come to a final decision about all the details of a statutory cause of action. We took the view that it was very important that any cause of action be certain, and that we wanted to leave as much uncertainty in what we had recommended as possible, because we took the view that people could really only decide whether or not they supported an action, a statutory action, rather than leaving privacy to develop at common law, if they knew exactly what they were looking at, what would be the fault element, whether or not damage was required, what was meant by serious, and how we were going to deal with the protection of freedom of speech and other matters of public interest, which inevitably have to be balanced against privacy protection. It was a privilege, I must say, to work at the ALRC on this inquiry, and particularly to lead a fantastic team of legal officers, and with all the support that the other members of the ALRC provide. In addition to that, we had a number of enthusiastic interns at different times who would come in and be really helpful in burrowing into a particular issue or helping us with the fine detail of all the citations and so on as we got to the end of the report. But one of the wonderful things about working at the ALRC on an inquiry like this is the collegiality of the task. Every single person at the ALRC is involved in the task of getting that report, getting the discussion paper, getting the issues paper out. And it was wonderful to be working with such a directed team like that, of very talented legal officers and others. So obviously my most important work, I suppose, during my time at the Commission was the production of the report. I like to think that it's much more than just the detailed legal design of a statutory cause of action. We had a chapter on harassment, we had a chapter on surveillance devices, and we had a section on new regulatory mechanisms as alternatives to court action, which we felt were very important. In particular, the chapter on surveillance devices in our federal system, I think is a very important chapter, because currently Australia is subject to more than 7 different legal systems in relation to surveillance devices, and surveillance in the digital era has become one of the massive issues of invasion of privacy in all sorts of contexts. I would like to see the government and the members of Parliament perhaps take a little bit more time out of their busy schedules to read the fine details of the report. And I suppose that brings me to another point. What are the major reform challenges going into the future for the Law Commission? I suppose one of the things that I would like to see is a little bit more legislated structure for the consideration of Law Reform Commission reports. Perhaps not something exactly the same as happens in the United Kingdom, where the Law Commission can actually introduce bills into Parliament for non-controversial matters, but something more than simply the tabling of a report in Parliament, where there is a little bit of suspicion that it gets then put on a back shelf. I would like to see some structure in the legislation for parliamentary consideration of the recommendations and a debate and information given to all members of Parliament about that, so that at least the issues that are put up by the Law Reform Commission could be aired in the Parliament. I'm a great fan of Law Commission reports. I think it's wonderful that we have this system of very careful consideration of options and consultation with a very large number of stakeholders. It's really part of democracy at work, I think. And what was also interesting is that some of the stakeholders took a very responsible attitude to their task. They realised that although they were talking for themselves and what they would like to see the law being, they also took a broader view of whether or not we need law in a broader context, the way in which privacy, for example, might affect other people rather than just themselves. I mean, obviously, for example, privacy affects the media, it affects big business, but it also affects individuals, such as people who are the victims of revenge porn in a family violence or family breakup situation. Those are very different contexts, and one of the challenges was to design a law where one size fits all. But I feel that we had a very good shot at doing that. What I would like to see is further consideration of the report in the future.